Good morning, everybody, and welcome or welcome back. Good morning, everybody, and welcome or welcome back to panels 5 and 6 of this year's Ethics Across the Profession Symposium, Judicial Ethics and Accountability at Home and Abroad. We start off today to a certain extent at home and then move abroad fairly quickly. And I think in terms of the panel discussions that we had yesterday, which were very rich and really appreciate the contributions. For those of you who were here yesterday, you know how dense the experience was and how many ideas threaded their way through all of those sessions. For those of you who weren't able to join us yesterday, we do have them all videotaped, but you'll get up to speed quite quickly. I think in terms of the themes that were being discussed about judicial ethics, codes of conduct, performance, evaluations, accountability, the democratic deficit, and the like, and we'll take a look at that both in the US context this morning and also internationally. My name's Paul Paton. I'm director of the Ethics Across the Professions initiative here and a professor of law at McGeorge, and it's my pleasure to welcome you all for a morning of what I know will be stimulating discussion. You will see that this morning we're actually engaged a bit with technology. And joining us by Skype, I feel like Oprah. Joining us by Skype is Mark Harrison. Good morning, Mark. Thank you very much for joining us.
Good morning, Paul.
Well, that's a good volume check. I'm just going to turn you down a little bit. What I'm planning on doing is actually an introduction to the panel first. I'll introduce all three of the panelists. Sarah Cravens will speak first, and then we'll go to Mark for comments, and then to Jim Moliterno. And as we move from the dialogue yesterday, made all that more important with the announcement yesterday afternoon of the retirement of Justice Stevens, and I'm sure some of you heard on radio this morning or last night, the speculation is already rampant about a replacement and about the confirmation process and all these issues. Haven't heard anybody's name in this room yet, but if I've forgotten to mention you, please let me know and I can correct that oversight. These issues about how judges comport themselves, and from yesterday's dialogue, how do we actually regulate their conduct in the Canadian context with no codes of conduct but with ethical principles, in the US domestic context, codes of conduct in various states or federally that seem to or not be working. And we're going to get into a dialogue this morning about some of these questions. How should judges be regulated? How should they be taught? And can American values be transmitted to judges internationally? And what might we learn from the experience of other systems? We're going to look at the creation of and implementation of judicial codes of conduct in domestic and comparative perspective, as well as efforts to educate judges. And I can think of three no better people to get us into that dialogue than our panelists this morning. Starting off, and whose paper is in your materials, you have Sarah Cravens, who's assistant professor of law at the University of Akron School of Law. She's been there since 2005 and one of the new generation of legal ethics scholars that I'm glad to be a part of in the US legal community. She got her bachelor's from Princeton, her MPhil from Cambridge, and her JD magna cum laude from Washington and Lee, where she was senior articles editor of the Washington and Lee Law Review. Her particular areas of research interest include legal ethics and judicial roles, and she teaches torts, professional responsibility, and a seminar on judges and the judicial role. She's been admitted to the Oklahoma State Bar as well as DC. She was a law clerk for the Honorable Stephanie Seymour in the U.S. Court of Appeals for the 10th Circuit and was an attorney for Arnold and Porter in the Washington, D.C. office. She writes on issues including the role of the judge, and in recent articles and books chapters has addressed directly this concept of impartiality, appearances, recusal analysis, and the importance of explicit reason giving in judicial opinions. So, Sarah, good morning and welcome. Look forward to the paper and the presentation. He's back. Your timing's impeccable, Mark. Mark Harrison is with Osborn Maledon, and he was the chair of the ABA's Joint Commission to evaluate the Code of Judicial Conduct from 2002 to 2007. So when we're talking to people about judicial codes of conduct, we've got the expert with us via Skype. Again, I feel like Oprah. Mark, it's a real privilege to have you. He's in Phoenix, Arizona, and actually was recently named the 2010 recipient of the National Conference of Bar Presidents Fellows Award, was involved in a ceremony there last night, couldn't coordinate flight schedules, but through the wonders of modern technology, delighted to have you with us this morning. His service is extensive. He's represented lawyers in disciplinary proceedings for more than 25 years, judges and the Arizona Judicial Conduct Commission in judicial discipline proceedings. It was his product that was unanimously adopted by the ABA's House of Delegates in 2007. He served as the president of the State Bar of Arizona, president of the Maricopa County Bar Association, National Conference of Bar Presidents president, and he received the Michael Frank Professional Responsibility Award from the American Bar Association in 1996, which those of us involved in the legal ethics and professional responsibility community with the ABA know is its highest honor and highest award for distinguished service in that community. So Mark, welcome. Thanks very much for joining us this morning.
Pleasure to be here, albeit by technology.
Okay, thanks, Mark. And then finally taking us, again, truly into the international sphere is Jim Moliterno, who is the Vincent Bradford Professor of Law at Washington and Lee. There's a Washington and Lee connection this morning with Brad Wendell formerly having been there. We've got a Washington Lee conspiracy or something in that effect. For 21 years prior to joining the WNL faculty in 2009, though, he was Tazewell Professor of Law and Director of the Legal Skills Program and Director of Clinics at the College of William and Mary, also serving there as Vice Dean in 1997 to 2000. He's taught legal ethics courses and professional responsibility and skills courses at 4 different law schools over the past 28 years. He's a member of the American Law Institute, has received numerous teaching awards and the like. We're very proud of his McGeorge connection as one of the co-authors of the legal ethics book in the Global Legal series that McGeorge puts out. Very proud of that product in terms of the globalization of education in America. In particular with this experience, and Jim will talk about it at greater length, he's actually done a considerable amount of outreach internationally. He has developed a course modeled at many law schools, but also used in Japan, Russia, the Czech Republic, Australia. He's designed new lawyers and ethics judges courses in Serbia, Armenia, Georgia, the Czech Republic, Japan, and Thailand, and has done law professor training in China, Thailand, Georgia, Armenia, and Serbia. He's worked to revise lawyer ethics codes internationally in Thailand and Spain, and this morning we'll be speaking about his experiences in Kosovo, so dealing with post-conflict states in that respect. So we've got a terrific panel to start the morning to talk about judicial codes of conduct, what they look like in domestic and comparative perspective, and please join me in welcoming our panel.
Thanks, Paul, and thank you, Mark, for your special effort to be here. So this paper gives an overview of some recent developments and practices in 4 other common law systems, those of Australia, Canada, England and Wales, and New Zealand, in which recent efforts have been made to address matters of judicial conduct regulation relating in particular to the promotion of public confidence in the judiciary. Some of these developments have happened even within the last few weeks and months, so there's really a lot going on. And what we do not see is direct imitation of anything that's going on in the US, and that's why I think it's an interesting thing for us to look at. As I said, I'm focusing on the idea of promotion and maintenance of public confidence in the judiciary because it's often given pride of place as the stated primary driving force behind other goals in conduct regulation. So due to my limited time this morning, I'm not going to try to define public confidence as an abstract concept. I'm not going to say why it's important or how we might reliably measure it and so on. I'm going to look at some highlights of things that are going on in these other countries as they've been recently developing new codes, new mechanisms for regulation to see what we can tell about public confidence by looking at something different from what we do. So a very quick overview, as quick as I can, of the basic setup in each of these countries, focusing on the national or federal system in each, to give you an idea of how varied the approaches can be. So in Canada, luckily, Richard, I just saw you a second ago. You gave us a little bit of an idea of the Canadian system yesterday, but we have the Canadian Judicial Council being established in 1971 with power over federally appointed judges. It is committed to fostering ongoing confidence in the judiciary. There's an aspirational guide to conduct that was written in 1998. But this most noteworthy thing to me there is that few cases of alleged judicial misconduct even get as far as a Canadian Judicial Council inquiry committee. Most are are either dismissed in early stages or they result in resignations. And so you don't get a big body of opinions explaining issues of judicial misconduct. There is an annual report with statistics and examples about how the process works, what the outcomes have been, and so on. In Australia, there is an aspirational guide to judicial conduct for federal judges that was written in 2002, which puts public confidence at a premium. The primary guiding principles are listed as to uphold public confidence in the administration of justice, to enhance public respect for the institution of the judiciary, and to protect the reputation of individual judicial officers and of the judiciary. There is currently no national conduct complaints handling system there. The Australian Senate's Legal and Constitutional Affairs Committee recently issued official recommendations for one, but that has been, quite interestingly to me, met with a lot of opposition by people who say the system's not broken. We don't need to do anything about it. Because complaints are dealt with on an informal basis by the head of a jurisdiction, sort of behind the scenes, it's only in the very rare cases of the proposed removal of a judge by Parliament that you really see things coming out into the light, and so there's no real body of judicial decisions on misconduct. The Judiciary of England and Wales has had an aspirational guide to judicial conduct since 2004. And in 2006, they developed the Office for Judicial Complaints, which is supposed to, quote, support the Lord Chancellor and Lord Chief Justice in their joint responsibility to maintain public confidence in members of the judiciary. These are civil servants who, alongside judges, manage, investigate, and make recommendations for discipline. There is also a separate Judicial Appointments and Conduct Ombudsman who was created at the same time as the Office for Judicial Complaints in order to audit and consider complaints about the work of the OJC. So you have two layers there of conduct regulation and oversight of the conduct regulation. And again, there is an annual report produced by the OJC that gives basic information and statistics about what's gone on, but very little in the way of actual explanation of the reasoning behind a decision. Finally, in New Zealand, you have a fairly unique approach because it's such a small community. In 2004 marked the creation by Parliament of a new mechanism for handling complaints about judicial conduct, the Judicial Conduct Commissioner, whose purpose is to enhance public confidence in and protect the impartiality and integrity of the judicial system. The commissioner is a lawyer who reviews all complaints about judicial conduct and can either unilaterally dismiss them on a number of enumerated grounds, can refer them to the relevant head of bench, or can establish a judicial conduct panel, which would include a judge, a layperson, and then either another judge or a lawyer who would deal with the complaint. That has never been used, though. Published reasoned cases on judicial misconduct basically don't exist in New Zealand. You can't find them. It's all sort of behind the scenes, even with the new act, and it was recently amended even a couple of weeks ago, and there's still nothing really about producing published reasoning. So some themes that emerge from the approaches of these systems and the reports so far about what they're doing. There are several questions that I think emerge as important ones that we need to look at. I will list those questions. I'm not by any means going to tackle all of them. So just for an overview, is there a written code? Is it publicly available? Is it binding? And what are the kinds of misconduct that seem to matter most in that code? Are there established consistent procedures for handling complaints, and are they known to the public? Who runs or oversees those procedures, and who's involved in the actual decision-making about judicial conduct? What are the official powers of the decision makers? In what degree and manner are the complaints, procedures, and outcomes made transparent and available to the public? And then finally, how do the answers to those key questions connect with the achievement of the goal of public confidence in the judiciary? So instead of talking about all of those, I'm going to hit some high points that I think bring out interesting aspects of these systems. So at this point, all of the countries I'm talking about have a written code or guide of some kind, although they're all advisory only and not binding. Again, New Zealand is unique here in that their code did exist as of 2003, but it was inexplicably secret until last year. Only judges knew about it. A lot of what those codes contain is exactly what you would expect about fairness and conflicts of interest and decorum on the bench, compliance with the law. So I'm not going to talk about all of that. I am going to pull out one piece here on appearance standards and the intersection between regulation of judicial conduct and appeal of legal issues, so where appearances meet recusals. Each of these systems indicates in its code or guide some level of concern for the appearance as well as the reality of proper judicial conduct. One of the most common areas for that to come up is recusal. The complication is that the recusal issues walk a line between true judicial conduct matters on the one hand and merits-related decision-making matters on the other. And each of these systems makes clear that you must draw a line, that the judicial misconduct mechanisms are not to deal with dissatisfaction with an outcome, they are to deal with dissatisfaction with judicial behavior. However, conduct that might implicate bias is often hard to clearly categorize in one camp or the other. So the former Australian Chief Justice Gleeson suggests that there's no way that public confidence would exist if people believed impartiality could not be achieved. But somewhere along the way, the concern shifted from the actual impartiality that would instill meaningful public confidence to just the instilling of public confidence itself, whether it's reflective of underlying realities or not. So let me just give you a few examples of where I've seen this come up in these other systems and how it's been dealt with. The one case from England in the year 2007-2008 in which a complaint against a mainstream judge actually resulted in a public reprimand was a case involving a judge's refusal to recuse on the basis of appearance of bias. As you read the opinion in the actual appeal in that case, you get a bunch of excerpts from the transcript that make it very clear this is not an appearance of bias case, this is an actual bias case. It's plain on the face of the opinion. There's some wildly intemperate behavior on the bench there. It's worth noting, though, that the only reason we have that opinion, the only reason we have the facts and the reasoning is that it was appealed rather than just sent over to the OJC for consideration as judicial misconduct. So you get a very full explanation there about exactly what's wrong with this behavior on appeal. What you get from the OJC is a 3-sentence press release that says, we have found there was misconduct, we have issued a reprimand, we now have full confidence in this judge. So very, very different sort of public treatments of those two approaches. A few different matters from Canada implicate not only recusal and appearances, but also alleged improprieties with regard to extrajudicial speech. In one of those, there's a disagreement between the inquiry committee of the CJC and the full committee as to the application of appearance standards, and you have the inquiry committee construing them narrowly, finding the judge in error for removing himself, and then the full committee determining that it was a proper recusal based on appearances, that should be considered broadly. In another Canadian case, you have a judge, this is the one that Richard was talking about yesterday, a judge becoming very publicly embroiled in a controversy about a private interest in a local development project. There you have lots of facts, lots of reasoning provided by the CJC, so no complaints there from me. But you have a flip-flop in that the inquiry committee there relied on appearance standards as the end-all be-all, and you have the full committee saying, no, we really need to worry about actualities. So that sort of inconsistency, ambiguity in the treatment of appearances at that intersection of conduct and legal merits is a tricky one, I think, for instilling public confidence. Last example on this point is from New Zealand. A recent case there concerning recusal appears to have created some amount of havoc within the office of the Judicial Conduct Commissioner, but has been profitable, I think, in that it has provoked some reforms. After a litigant is dissatisfied because he believes there's a conflict of interest with one of the judges who ruled on his case, files a complaint with the Judicial Conduct Commissioner. After a year and a half and nothing has happened, it turns out the Judicial Conduct Commissioner thought this wasn't the kind of thing he was supposed to deal with, so he had sort of put it to one side. He's told no by some lawyers. He's told no, this is exactly what you're supposed to deal with, but doesn't do anything about it. And so an appeal is filed. The appeal is taken up. It's decided. You get an opinion. saying, yes, he should have recused himself. The Judicial Conduct Commissioner has still not done anything. It's been over 2 years, I think, now. So we again, we don't know quite how that system is supposed to work itself out. There's confusion that persists, whatever the procedural mechanism that's in use. One other example of sort of a substantive point has to do with something that I think is at the heart of questions about the point of the regulatory regime and what role judges are really supposed to play in the public confidence arena. There are two ways in which you might sidestep the regulatory process. One of those is through apologies, the other is through resignations. So the Judicial Conduct Commissioner in New Zealand suggested over many years that there should be an option for dismissal of a complaint if an apology has been issued to the complainant and has been accepted. That has finally been taken up by Parliament in New Zealand, and what they said was that if the complaint has been resolved to the complainant's satisfaction by an explanation from the judge, that may be appropriate, but an accepted apology from the judge is by itself insufficient to justify dismissal. I tend to think that that's going to result in a lot of clever semantics about whether it's an explanation or an apology, but it really shows you the important question of, is this a private matter for the complainant to be satisfied about, or is this a matter for the public to be comfortable with if they only knew about the complaint? Canada has dealt with a similar issue in the case regarding the removal of Justice Cosgrove. After much emphasis on public confidence and the importance of public confidence, they considered the fact that Justice Cosgrove had issued apologies for his conduct. And they wrote, even accepting that the judge's apology was sincere, we must consider an additional, more important aspect in deciding whether a recommendation for removal is warranted: the effect upon public confidence of the actions of the judge in light of the nature and seriousness of the misconduct. For the council, therefore, the key question is whether the apology is sufficient to restore public confidence. Even a heartfelt and sincere apology may not be sufficient to alleviate the harm done to public confidence by reason of serious and sustained judicial misconduct. And indeed, in that case, they decided the apology was not sufficient. With resignations, I think it probably seems a lot simpler that if what you really want is confidence in the bench, then if you have a bad judge, you want to get the bad judge off the bench, so you'd like to get them off the bench however easily that might happen. The one question I have there is, should there be public analysis or explanation of what went on to provide an opportunity for the public to learn about the judicial role, for the development of a body of reasoning about judicial misconduct? The Judiciary of England and Wales seems to be making a little step forward. They're still not providing reasoning in those cases, but they're at least making public statements on their website about when a judge resigns in the face of a conduct complaint. All right. Switching over from substantive issues to procedural, a couple of highlights there. I would say while there is great variety in the procedural approaches used in these different systems, there is generally agreement that public confidence is enhanced by public awareness, that there are mechanisms in place for consideration and handling of allegations of judicial misconduct. The one notable exception is that debate I mentioned earlier in Australia about whether the system really needs to be fixed, because some say it's not broken as it is, and others say, how can we know if it's not broken, if it's all behind the scenes and we don't actually know what's going on there? So that, I think, is still a bit of an open question. The two procedural points I'd really like to focus on here is, one has to do with the identity of decision makers and the other has to do with publication of reasoned opinions. So, are the people making the decisions about judicial misconduct insiders or outsiders? And which would be to the greater benefit of public confidence in the judiciary? We see different approaches here. As I mentioned, in England, you have the OJC, which is basically run by civil servants, although ultimately the decisions are made by judges. And that sort of incorporates the idea that the regular people off the street have an opportunity to participate in the decision making here. New Zealand has this provision for a judicial conduct panel, which would incorporate a layperson into the decision-making process, but it's never been used. So that sort of diminishes its quality, I think, for promoting public confidence. But you do have the Judicial Conduct Commissioner being a lawyer and not a judge, which is slightly less insider, until you look at the great problem of conflicts of interest, which has come to light. All these people who are elite enough to be a Judicial Conduct Commissioner are friends with all the people who are judges, and therefore have a difficult time sort of separating themselves. And they have now, as of a couple of weeks ago, they've established a new position of the Deputy Judicial Conduct Commissioner, who can come in when the Judicial Conduct Commissioner thinks he can't make a fair decision. The question I would raise there is, if we're really concerned with public confidence, if that's the end-all be-all, why not have it be like jury duty, right? Why not just have people, average people off the street, participate in this decision-making? And yet we have none of these systems actually adopting that approach, which makes me wonder, exactly what do we mean by public confidence? So last point has to do with transparency and publicity related to judicial misconduct. And the question here, I think the big question is public confidence going to be hurt or helped by knowing all of the details about how the sausage is made and all the ways in which it can go wrong? Is it better to say, look, these things go on and we get the judges off the bench or we discipline them? Or is it better to say, don't worry about it, we're dealing with it. Complaints come in, we deal with them. As I mentioned, in Canada, you do get, when something gets to the level of an inquiry committee, you actually get a very meaty decision. You get lots of reasoning, lots of facts. In Australia and New Zealand, there's almost no information available to the public about reasoning in cases about judicial misconduct. In England and Wales, we're somewhere in the middle. There's still not a lot, but there is more information in general. By contrast, there's all this effort that's going into these annual reports on statistics. And I think that raises the question of whether people who aren't insiders to the system, whether people who aren't sort of deeply concerned with exactly what goes on in the judicial role, are actually better served in terms of their confidence by just knowing the statistics, just being told, look, here are how many cases came in, here are the kinds of judges they were about, here are the kinds of cases in which the complaints were made, and here are how many reprimands and how many removals there were in a year. Is that actually better for the general public than long and complicated opinions? Last point there is that there is considerable effort made in at least 3 of these countries to publicize the process, to make it very available on their websites, to give examples of the types of behavior that might be appropriate for a judicial conduct complaint and the types of behavior that wouldn't. So I think those are probably really good and helpful efforts in the move towards greater public confidence in the judiciary. So a few conclusions. Again, former Australian Chief Justice Murray Gleeson has said that the best way for judges to gain public confidence is simply to do a good job. But we can't quite leave it at that, I don't think. I think we have to dig a little bit deeper. So that I think what I see, and again in broad brush strokes, is that to the extent that these systems involve lay people in some way, either in participation in the process in some way, or simply in informing them and making efforts to educate them, that's got to be good for public confidence. To the extent that they withhold information, though, about the reasoning, I think they may be doing a disservice to public confidence. That the annual reports that give the statistics may be helpful, but if you look at something, for example, this is again from the CJC, Canadians can have confidence in their judges. From tens of thousands of judicial hearings that take place every year in Canada's superior courts comes a very low number of complaints. And my question is does that really show us that there's public confidence, or is it simply a coincidence? So ultimately, I think even the process of looking closely at the mechanisms used, the provisions written up by each of these systems will be useful in better understanding how we might improve existing systems with innovations or refinements to make judicial conduct regulation as broadly effective as possible. And in the question period, if it's helpful, I'm happy to sort of try to translate some of this into the new rules for the federal judges in the US, if that would sort of make things click.
Thank you very much, Sarah. Terrific. We're going to go full screen with you, Mark, so just hang on a half second here. One of the things that you have in your materials packages is Mark's article from the Justice System Journal in 2007 entitled The ABA Model Code of Judicial Conduct Blueprint for a Generation of Judges, which goes into considerable detail. And Mark, I'm hoping that you'll talk about this as what Sarah and others have labeled the sausage making, in dealing with the process of actually arriving at this model code, and perhaps also addressing the question that I think implicitly comes out of Sarah's discussion, which is, well, everywhere else in the world is looking at codes and the like, but none of them is adopting the US model. So with that, over to you, and thank you very much indeed for joining us.
Thank you, Paul. First of all, can you all hear me?
Yes.
Yes.
I want to thank you for inviting me to participate, and my apologies for my inability to be there in person. I want to thank Paul and his assistant Ashley and their IT guru for getting this 75-year-old guy with you by technology. It's pretty exciting. As Paul indicated, I was asked to participate because of my involvement as chair of the ABA Commission to evaluate the Code of Judicial Conduct. By way of a little background, my prior experience before that assignment was in representing judges in judicial discipline proceedings and in representing the Arizona Judicial Conduct Commission in the prosecution of judges. That was the extent of my familiarity with judicial ethics prior to my appointment as chair of the commission. The work of the commission sort of took over my life for 3.5 years. We had 14 public hearings around the country. We had 45 meetings before we were through. And it ultimately culminated in unanimous adoption in February of 2007. For your information, the commission was comprised of 10 members, including a public member, an academic, federal judges, state judges, lawyers, and then there was an advisory group comprised of representatives of all of the groups that have an interest in the judiciary. The American Judicial Society, the Conference of Judicial Conference of the United States, and so forth. The work on the code was significantly assisted by two excellent reporters, Professor Bill Hodes, with whom you may be familiar, and my friend Charlie Jay, who you heard from yesterday. I'm frankly, perhaps justified, perhaps not, extremely proud of the work of the commission because since February of 2007, the model code has already been adopted with relatively minor variations in 12 states and is far along in the adoption process in 26 other states. Frankly, no other code adopted by the House has moved through the states with that kind of rapidity. Since the code was adopted, I've been asked to serve as a consultant to several states that are considering the adoption of the model code. And so I've had a continuing experience with the problems associated with the code and its implementation. Paul asked me to review the paper submitted by Professor Cravens and Professor Moliterno, and I got them a few days ago, and I've reviewed them, and frankly, I found them very enlightening and very interesting and very provocative. I have to confess, my only prior experience with judicial ethics outside of the United States was in China. In the year 2000, I went with a group of lawyers and judges to China to put on a program dealing with judicial ethics. And I must say, I was very sympathetic to the experience that is described in Professor Moliterno's paper, because in China, we were dealing with a different culture, different traditions, and a different system. And it presents rather unique problems for those of us who come from the US tradition. The provocative question that recurs, if I may use Professor Craven's first name, Sarah's paper, what do we mean by public confidence in the judiciary, reminded me of that often quoted statement of Justice Potter Stewart in Jacobellis versus the United States: I can't define pornography, but I know it when I see it. I think at some visceral level, we probably all think we know whether public confidence exists in the judiciary in our respective states, or perhaps in the country. but I doubt that any of us can demonstrate the existence of public confidence on an empiric level. I was not surprised to learn that the judiciary in the countries discussed in Sarah's paper are at least rhetorically committed to the core values which are the foundation of judicial regulation in the United States: integrity, independence, and impartiality. What I found extremely surprising about the judicial conduct systems discussed in Professor Craven's paper were, admittedly with some variations, the lack of a coherent set of rules or standards for use in the regulation of judicial conduct, the lack of regulation itself, the lack of transparency in dealing with judicial conduct, and I couldn't help but be reminded of the debate that has raged in the legal profession for years about whether the lawyer discipline process should be open to public scrutiny. And I've been actively involved in efforts to open that up, because it finally dawned on me about 30 years ago that if the public is to have any confidence in the integrity of the profession and its disciplinary process, it's got to be relatively transparent. And that's similarly obvious in the context, if not more so, in the context of judicial regulation and discipline. The final thing that struck me about what is lacking in those that Sarah studied is the lack of any meaningful public accessibility to real information relating to the handling of judicial misconduct. My surprise about what I regard as pretty fundamental deficiencies in their systems may be attributable to my naive and unsophisticated assumption that these countries, some with common law traditions much longer than ours, would surely regulate judicial misconduct as rigorously as we do. But the observations about the handling of judicial misconduct in New Zealand, Australia, Canada, and England, and Wales reminded me of what I hear bar leaders talk about all the time. They lament constantly about, what are we going to do about the lawyer's image? How can we improve the image of the legal profession? And unless I misunderstand Professor Craven's observations, much of what passes for regulation in the countries she studied are cosmetic fixes. And let me say, if I've overstated the situation or offended any participants from those countries, I'm at least comforted to know that I'm safe from retaliation at this distance. I can't help but compare what Professor Cravens has observed and learned from her study of the 4 common law countries in her paper with the model code, with which I am quite familiar. Think about this in light of what Professor Craven said. The model code categorizes clearly stated rules in functional terms. It groups those rules affecting the judge's conduct at all times. Those are the first couple of rules. Then it has a section dealing with rules affecting the judge while functioning as a judge in a judicial capacity. Then it has a set of rules governing the judge's conduct while involved in extrajudicial activities. And it has, finally, rules which vexed us for 3.5 years, rules governing judges' conduct in political campaigns and political activities. Start with the proposition that these rules are designed to be enforceable. They're designed to regulate conduct. And I didn't hear much of that in what goes on in the UK and in Australia and New Zealand. The rules in the model code are followed by comments, which are designed to be both informative and aspirational. The model code, I should be quick to add, does not include rules governing the enforcement process itself. In most states, those rules are separate and apart. They're codified in a separate document, which is administered and enforced by an independent body and professional staff, which almost invariably include at least one or more non-lawyers. In some states, but not all, information about judicial discipline, both individual cases and annual statistics, is publicly accessible either in print or on the website of the highest court in the state, or both. The transparency of the process and accessibility of information about the process presumably instills some measure of the public confidence about which Sarah spoke. Now, obviously, this isn't universally true. The model code isn't a panacea, and the systems that we have in the United States are not perfect. And let me start, and if there are any federal judges in the audience, forgive me. Again, I am comforted by my distance from tomatoes. The federal system, frankly, has been a disappointment to me. We had a federal judge on our commission. As you may know, I don't expect you're all judicial ethics junkies, but the Code of Judicial Conduct governing federal judges is virtually identical to the Model Code of Judicial Conduct, with one very material, important difference. Every place that the Model Code of Judicial Conduct says the judge shall or shall not do something, the comparable federal code says a judge should not do something. So in a very basic way, the code governing federal judges is largely precatory. And frankly, when we found out that the committee that was looking at the model code adopted in 2007 was going to reproduce a new federal code that preserved this discretionary should language, we wrote a long letter and said, the problem with that is, it really isn't a regulatory document. And if those of you who follow this field carefully think about the kinds of criticisms we've been hearing about the lack of consistent discipline in the federal system, you can appreciate why that was very troublesome to us. Because in many ways, what was on in the federal system sounds like what Professor Cravens discovered in her review of some of the systems abroad. Other problems with some of the state systems is that there is still too much privacy and secrecy. For example, in Arizona a few years ago, what used to be private admonitions that were non-public were made public. So there is virtually nothing that goes on now that isn't publicly accessible in Arizona. Other things which affect the whole issue of public confidence, and which really have very little to do with judicial ethics as such, is the corrosive effect of money in judicial elections, and the lack of meaningful information about judicial candidates in those states which have popular elections. So let me digress a moment. At the risk of paternalism, I can't help but talk about Arizona. Arizona adopted the new model code effective September 1 of last year. Arizona has a merit selection system that was adopted by constitutional amendment in 1974, and over the ensuing 15 years, increasing pressure arose to make the system more accountable. The argument was merit selection judges are running only against their record, they don't have meaningful opposition, and therefore they're not really accountable to the voters, whatever that means. So as a result of that, the legislature adopted, and it was adopted by the people, another provision of the Constitution which provides for judicial performance review. And it's codified in the Constitution at Article 6, Section 42 of our Constitution. And if any of you are really junkies, I wrote an in-depth article about that system, which appears in the Fordham Law Journal, Volume 34, January 2007. Judicial performance review is very significant because it's significant in the context of Professor Craven's comments. Judicial performance review establishes a commission comprised of 30 members. The composition is specifically required to be reflective of the community as a whole. So there's ethnic and gender diversity, geographic diversity. Terms are 4 years. Members are appointed by the Supreme Court. There can be no more than 6 judges, no more than 6 lawyers, and a majority of the commission has to be public members. Legislators can be present in a non-voting capacity, and what we call JPR develops and implements standards to measure judicial performance. And they survey, using these standards, they survey the opinions of everybody concerned and involved with the justice system: jurors, attorneys, litigants, witnesses, and court staff. They compile evaluation reports and send them to every registered voter in the state. They're available in public libraries and in other public offices. In my view, admittedly biased view, this provides far more accountability than partisan elections involving big dollars, TV sound bites, and very little objective, hard information about the candidates running for office. Now, I can't claim to be able to answer Professor Craven's questions about what public confidence means or whether there is public confidence in the Arizona judiciary. But despite my ability to establish this empirically, Arizona courts have been described by a number of very disparate groups as a model judicial system. Groups as disparate as the Chamber of Commerce, Legal Women Voters, and so forth. And I think the reason that it has gotten such high marks are attributable to factors that are notably absent in the 4 countries that Professor Craven studied. Merit selection of judges, including a group that includes public members. Judicial performance review, which evaluates conduct and publishes data widely disseminated involving public members. The Code of Judicial Conduct, which is regularly enforced. We have more judicial sanctions in a year than those 4 countries have had in the last 10. Rules of judicial discipline enforcement. Again, a commission that judges judicial conduct, including public members. Transparency, public dissemination of information related to the judiciary, and the public accessibility of information. In my view, while there's no quick definition of what public confidence means, it seems to me, from what Sarah said, and from what I read in her paper, that an awful lot of this relates to the involvement of the public in the process, the availability of information relating to the process, and a demonstrated commitment to regulating judicial misconduct, as evidenced by sanctions actually imposed. Most of these kinds of initiatives and characteristics and systems are pretty much lacking, as I understand it, in the country studied by Professor Cravens. A little postscript before we turn brief Professor Moliterno's paper. Do I have time, Paul?
I was going to say, if you got a couple of minutes, Mark, and then we'll go to Jim. And hopefully you can stay with us afterwards. We'll try and keep the line open.
Sure. The success of the Arizona system is best evidenced by the fact that for every year for the last 20 years, various groups that have ideological interests or special interests try to get rid of merit selection and judicial performance review. Let me turn briefly to Professor Moliterno's paper. It really reminded me, Professor, of my trip to China, because we were confronted with a totally different culture, totally different traditions, and a different system, such as it was. And again, I was stunned by the fact that here we have a country which had a highly developed civilization long before we ever thought about being a nation, whose judicial system was, by our standards, extremely primitive. That said, Professor Moliterno might appreciate this little aside. When we got to China, those of us from the U.S. who were going to be presenters at Fujian University spent a half a day with the U.S. Deputy General Counsel, who wanted to make sure that we weren't presumptuous about telling the Chinese how they should run their judicial system, and that we should be very respectful of their traditions. Well, of course, I think all of us instinctively would have done that. But the fact is that I sensed that throughout Professor Moliterno's paper. He was dealing with a completely different system. It's hard for me to tell whether Kosovo or Kosovo, depending upon the spelling, ever had a well-developed judiciary that in any way resembles our judicial systems. Yet, what came through in Professor Moliterno's paper is that despite established traditions and clear-cut systems, at some level, those judges understood and at least were committed intellectually to the core values which inform the work of judges here: independence, integrity, and impartiality. But they were having difficulty, as I understood it reading Professor Moliterno's paper, having difficulty translating those values into practice because those values were not part of a hallowed tradition, as they are much more so here. It occurred to me, for example, when reading the discussion of a hypothetical involving an ex-parte conversation.
Actually, Mark, if I might interrupt you there, rather at this point, it actually might be good to go to Jim's paper and then have you come back for additional commentary on it, if that's all right by you.
Happy to do that.
Terrific. Thank you very much.
Sure.
Okay, we'll come back to you in about 20 minutes, Mark. Thanks.
Can I hear?
Yes.
Okay.
Thanks, Paul. Thanks, Jim.
So thank you very, very much. Thanks, Paul, for the invitation. Thanks to everybody here at McGeorge who's been involved in any way with this really first-rate event. It's been a great pleasure to be here, to meet your students, to meet the law review folks, and everybody's been marvelous. It's just been wonderful. All the other speakers, or really nearly all the other speakers, Sarah and a lot of the folks yesterday, have had to do a lot of research for their papers. They've documented a lot of things. They've got a lot of footnotes in their papers, and they've done everything. My treat is that I get to spend a few minutes with you doing nothing more than telling you about some engaging, challenging, I hope meaningful work that I've had the privilege and joy to do in Kosovo for the last few years. So that's kind of easy for me, right, by comparison to what a lot of other people have been doing here in the last day or so. And I go back in 10 days for another trip and another session that I'll get to spend there, so it's going to be great. So you want to start imagining what it would be like to teach judicial ethics in a place like Kosovo. The law and lawyer culture in that country are remarkably complex. Until 2008, Kosovo was a province of Serbia, and more than 100 countries today say it still is. It's a contested state, recognized by the US and about 60 other countries, but not including Serbia, obviously, or Russia, or about 100 other countries. So it's a country, or it's not a country. We're not quite sure. From 1918 until 1992, at which point Yugoslavia began to disintegrate, it was obviously a province of the Republic of Serbia within Yugoslavia. From the end of World War II, Yugoslavia was a communist state. In 1974, the Yugoslav Constitution granted Kosovo substantial autonomy from Serbia while still maintaining its status as a province. Following Tito's death in the early 1980s, Serbian domination of Yugoslavia and Kosovo increased. The autonomy that was granted to Kosovo in 1974 was revoked by Serbia in 1989. The 90s was a decade of conflict in former Yugoslavia, first in a modest way in Slovenia, a bit more in Croatia, far more intensely still in Bosnia, while the conflict in Kosovo simmered during all of that period of time and really erupted in the late 90s. During the late 90s, the conflict peaked in Kosovo, and there were untold numbers of Albanian Muslims who were killed or who were sent fleeing. The pictures of the dead as you walk through Pristina, the capital, pictures of the dead line a fence that surrounds a government building, and it's quite striking. When you drive through the countryside, you pass gravesite after gravesite after gravesite of monuments marking the deaths of martyrs and heroes. After the NATO bombing effectively removed the Serbs from Kosovo in 1999, Kosovo came under UN control. And the EU now is taking the reins from the UN, even while Kosovo has its own independent legislature, it has its parliament, it has some trappings at least of an independent state. In the northern part of Kosovo, across the river that divides a city called Mitrovica, the northern part remains under de facto Serb control. There's actually a shadow government elected by Serbs, paid a salary by the government in Belgrade. They meet and have no official authority of any kind. When you cross the bridge from the southern part of Mitrovica to the northern part of Mitrovica, you encounter uniformed Kosovar police on either side. This is not a border, but it's a border. On the south side, the people in the police uniforms are Albanian Muslims. They take their orders from Pristina, from the government of Kosovo. On the northern side, the people in the uniforms, the same uniforms, are Serbs, who take their signals from Belgrade, even if not their official duties coming from there. Both sides of the river are in Kosovo, or both sides of the river are in Serbia. Depends on whether you recognize Kosovar independence. The law and court system are complicated. There are old Napoleonic codes that essentially slept during the communist half-century. Some Yugoslav laws remain. The laws of the 1990s exist, but they're held in low repute because they were adopted by the Serb-controlled government, which has now been essentially sent away. From 1999 to 2008, the law was adopted by UN directives and administered by the UN High Representative. Now the fledgling Kosovar parliament adopts its own laws, most of which are proposed by international NGOs that are either based in the US or in Western Europe. And under all the wrappings, it's a legal system that's a basic civil law system, although it sports a slightly more adversarial dispute resolution system than the one that is most common in civil law systems. When the local parliament was encouraged to adopt the US-style plea bargaining system, the local parliamentarians balked and said that they were afraid that it would fuel judicial corruption. They were right. The older judges and lawyers were educated in communist forms. The new ones are being educated by this uncoordinated conglomeration of NGOs in concert with the newly formed Kosovo Bar Association and the Kosovo Judicial Council. These lawyers, none of them, of course, live in the US culture or legal culture. They're not common law lawyers, yet their adopted lawyer and judicial ethics codes have some relationship to our own, and were essentially encouraged by our ABA efforts in large part. In a bit of a tussle between the US and the European NGOs for their relative influence, this US style stands alongside the recent adoption of the French notary system, creating the common Western European branch of the legal profession that generates various documents, especially regarding property transfers, and of course, the lawyer code doesn't even contemplate such a lawyer. I could have made you a PowerPoint that would have listed all these events and dates and changes and modifications, but I wanted it to be as confusing to you as it was to me. I hope I've succeeded in that. Even my phone is confused when I go to Kosovo. So those of you who do a good bit of international travel know that when you land, you turn your phone back on, a little text message comes to you and it says, "Welcome to Spain." Gives you some instructions on how to make local calls. "Welcome to Slovakia." Gives you some instructions on how to make local calls. When you land in Kosovo, your phone text message says, "Welcome to Monaco." And you look around and you say, "This is not Monaco. I like it here, but this is not Monaco." As it turns out, Kosovo doesn't have its own country code yet. And Monaco apparently was nice enough to loan it some phone numbers. So your phone thinks you are in Monaco, and you are not. So since early 2008, in this very confusing setting, I've been involved in this judicial ethics training project in Kosovo. And I keep saying it different ways so that I'll offend everybody or no one, because it's pronounced different ways by different people there. This particular project, unlike some of the ones, Paul mentioned a number of the other projects I've been involved in internationally. This one is managed by the National Center for State Courts, which is a recipient of a USAID grant, and their job there is to accomplish certain institution building, legal institution building projects, and that's what this is. The broad strokes of the project were really designed by NCSC staff and also by the Kosovo Judicial Institute. And what it involved essentially was a wave of what they called basic ethics training, followed by a wave of what they called advanced ethics training, and also a couple of training of trainers projects, so that the project would be able to continue with local people doing the work after the money runs out from the grants and so forth. There's an Albanian law teacher, his name is Gent Ibrahimi, and he was asked to do the basic training sessions. And his training is essentially a PowerPoint project that he kind of walks through the language of the code and talks about some of its nuances with the judges. His training takes place regionally, as mine does as well, which follows his. And so we do the training in Pristina, which is the capital, but also in Prizren and Peja, Mitrovica, Tirande, and Ferzai. All wonderful places, marvelous places to go. The basic training then is this kind of walk through the code with Gent, and he does that. What I was supposed to do was to do something they just called advanced training, but they didn't say what they wanted me to do, thank goodness. They let me decide what I wanted to do. I was told that I should assume that the judges in my advanced training would have already had the basic training. That turned out not to be the case, and most of these kind of projects sound really good on paper in terms of their organization and styling and phasing and all those sorts of things, but it didn't really turn out to be the sort of pace and sequencing that they had in mind, I'm sure. I've had judges who have come twice or three times to my training day, which is the same training day because it's done regionally. I'm supposed to do the same project, and they cheerfully discuss the same hypotheticals with me and enjoy the coffee and so forth. So I was to do the advanced training, and I think what they expected me to do was to do a more detailed PowerPoint or a more detailed kind of exploration of their code. But as I started to examine before my first trip materials that were in place, the ethics codes that are in place, various UNMIC provisions, the United Nations Mission in Kosovo, regulations on courts and judges and prosecutors, studied materials on the independence of their courts and the way that they're structured, reviewed and commented on the basic training that Gent was doing, and did all those things, I realized that my head was spinning, that I really was very, very confused about how I would become some instant expert on the nuances of their code. Now, I found out as I went along that most of the time my confusion was a result of my incapacity to understand. But occasionally, my misunderstanding or my dizziness was the result of terrible translations. So obviously, I'm reading their materials, which are in Albanian. I'm reading them in English. I don't have any Albanian. I don't know if anybody in the room does, but I don't. And so there were times when I got a better translation and realized, oh, the reason I don't understand this is it doesn't make any sense, the way they've translated it in the first place. Nonetheless, what I decided, a kind of key decision at the beginning, was I was not going to do a PowerPoint for them any more than I did one for you. I was not going to try to do some more elaborate explanation of their code. I was not going to get into more depth on the touches in their code. I was going to focus on the judicial attribute that exists everywhere, if we're even going to call somebody a judge, and that is impartiality. So I was going to spend an entire day with each of these groups of about 30 judges in these different regions talking only about one thing, and that was going to be impartiality. I'm disturbed now. I knew of some of this literature from yesterday morning already, but I'm now disturbed that there's no such thing as impartiality, so I don't know if I'm going to be able to keep doing it. But with this single focus, rather than trying to do something with the breadth of their code, it occurred to me that I could make a full day that would engage the judges, would challenge their intuitions, leave them with much more lasting impressions than I'm able to leave somebody if I just stand up and use PowerPoint behind me. So the old proverb that many of you probably know is, tell me and I will forget, show me and I will remember, involve me and I will understand. I wanted to involve them. Only a little bit of telling, mostly showing and involving, and that was my plan. So in brief, I fashioned a training day that would begin with a very brief lecture on impartiality and independence, then a series of hypotheticals, then role plays, and lots of coffee to punctuate the day as you go through in deference to the local culture. At the first training, I tried to do the role plays by setting up little groups of three judges, each one had a role, each one, they would go off in their group of three, they were to play out the role, discuss it, come back, we would, like I might do in one of my classes here, right? And that was a disaster. So my first effort at doing that role play was a disaster. The difference in language, my inability to monitor what they were doing, my inability even to convey what I wanted them to do, turned out to make that very counterproductive and distracting. They essentially went off and instead of playing the roles, they read the materials, put their arms around each other and said, so we're supposed to give him an answer to this hypothetical or dilemma, right? Which wasn't anything like I wanted them to do. So I changed that, as I'll describe to you more in just a moment. So more specifically, here's how a typical day looked like once I learned my lesson from the first day, right? After a little bit of ice breaking with them, comments to demonstrate my knowledge of some local event or some local historical artifact in their city or whatever it happened to be, I would just talk a little bit about the agenda. And I would explain that the day would proceed in a particular way, that it was going to be quite different from what they had been accustomed to. It was not going to be ex cathedra training that they might be familiar with. I said that contrary to their customary expectations, I would not talk at them for more than 30 minutes at the beginning of the session. Remember, they all have headphones on, and so they're hearing what I say in English, they're hearing it in Albanian 5 or 6, 10 seconds later. That phrasing that I would not talk at them always got smiles. And you had to kind of wait and let it, okay, let that happen, and then, everybody would go, okay, we're going to do something different. And they seemed happy about that. So the entertainment made its way through the headphones in about 6 or 8 or 10 seconds. So I gave this brief lecture, again, not more than 30 minutes, certainly, on impartiality, trying to distinguish the notion of impartiality and describe its relationship with the compatible kind of corresponding notion of judicial independence. Bam, 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 that's done. Okay. From that point on, together with co-trainers, because they would always have for me an experienced judge, sometimes an experienced prosecutor, local people who were going to be my co-trainers, we would start discussing this series of hypotheticals. The materials I gave them had 7 hypotheticals. I never got past the third one because the discussions became so lively, the discussions became so animated. The very first hypothetical was deceptively simple. Here's all it is. It says, judge regularly hears cases involving bank. Judge's son currently has a loan application pending at bank. Is this a problem? Is this a problem? They reacted as you might guess they would. They were mad at me because without my having commented yet on the hypothetical, they assumed that as an outsider coming to lecture them on ethics, I thought everything was problematic. Everything I would say to them, every hypothetical they were used to having be a problem, something wrong. You can't do this, right? And judges' children can apply for loans at banks, right? And so their reactions were a little bit upset. They would say things like, how can our families live? Must we not buy groceries at the market if the market has cases in my court? Must my children never trade with a bank if I live in a small town and the bank has to be in my court? Some judge must hear the bank's cases. What of her children? And I would listen and listen and listen and process and say, you're right. I agree with you. And they would be disarmed because they didn't expect me to say, the bare bones of this hypothetical may not be a problem at all, right? So I would say, tell me what would make it a problem. Tell me, add something to this hypothetical that would make it be problematic. And they didn't have any trouble doing that. What if the bank gives my son the loan at a more favorable rate than they give it to anyone else, hoping to gain my favor? What if they call and ask me if I'll be grateful? Grateful was the phrasing for asking for, corruption. What if they call and ask if I'll be grateful if they make the loan? What if I call them because I'm worried my son doesn't get the loan? And on and on and on. What happened in these conversations for them, I think, was that they weren't merely presented with a hypothetical that was on one side or the other of the line, if you will. They were presented with one that was over here, and they walked it across the line. So instead of just seeing an example that's over here, an example that's over there, they saw the line. They were able to actually articulate what would be problematic about this situation if it were different from the bare bones fact pattern. The second hypothetical was just as simple. It involved a judge who was presiding over a case where the plaintiff said that she had bought many gallons of some paint, applied the paint to the wood on her house, and it had destroyed the wood. It had damaged the wood. But the judge had also used the same paint a few months earlier with the same result. Is this a problem? Here they debated back and forth whether this was really a problem or not, and they fought about it, and they fought about it, and they fought about it. It was marvelous. And I would be able to say, look how simple this hypothetical is, and yet the greatest judicial minds in the country are disagreeing with one another, right? Here, what I did was I forced them to get underneath what troubled those people in the room who thought there was an impartiality problem, and I forced them to say, why? Why is it a problem? Why is this an attack on the judge's impartiality? And they always managed, might take an hour, but they always managed to come up with 3 reasons they could articulate. Number 1, we want judges to come to disputes without prior factual knowledge of the disputed facts. And here the judges use the same paint with the same result. He already comes to the table with knowledge of the facts, or he thinks he does. Number 2, we want judges to be free from prior bias against one party or the other, and this judge might already be mad at the paint company who's already kind of damaged his property in one way or another. And 3, we don't want judges to have any personal stake in the outcome, beyond some de minimis thing, right? And so this judge may be setting, in some loose way at least, some sort of precedent by deciding this case for the plaintiff in a way that would help the judge bargain with the paint company on her own behalf later on. Forcing them underneath what caused the impartiality trouble was a great way to get them to see how they could analyze these everyday situations, not in any complicated way. Okay, we finished the day with, after a long lunch and lots of coffee, we finished the day with a role play in which my 2 co-partners, the judge would be sitting out at his cafe, enjoying the nice day. A woman would approach him and begin to talk with him about the trip that he had taken with her travel company the prior year. And the conversation is very nice. She flatters him. She sits down and has a coffee with him. But the next thing you know, she's telling him about her son's case that's pending in his court, and why her son is not guilty, why her son has been manipulated, why he should rule in her son's favor, and on and on and on. And my time is up, so I'm just going to leave with you the idea that we then would develop this role play through a discussion with them. Sometimes I'd get up and replay the judge's role. Sometimes one of the judges from the audience would get up and replay the judge's role and play out what it is about ex parte contact that disrupts impartiality, why it does and why it doesn't. So I know we're out of time and we're moving on, I think, right? Okay.
Thank you, Jim.
Yep.
Mark, here's how we're going to actually work the balance of the session in order to be able to engage you. Can you hear me all right?
Perfectly.
Excellent. What I'd like to do is actually go back to you for the continuing comment, if you would, another minute or 2 on Jim's paper and your experience and reflections on that. Then I'm going to go to Sarah for a response to your comments, and then I'll come back up to the podium. I'm going to have to play with your microphone a little bit as we're doing this to repeat questions from or comments from the audience and to get the response of you and the other 2 panelists. Okay, so it'll be a little more complex than usual, but Mark, first back to you for additional, I kind of cut off your commentary on Jim's paper because I thought it would be best to hear him play it out first. So back to you for a minute or two of commentary on his experience.
Very briefly, Paul, Professor Moliterno was just telling you about the hypothetical involving the last role-playing situation, and I read that with great interest. The judge who's sitting in the cafe confronted by a woman who ran a travel program and who's now ex-partying the judge. And it occurred to me when I read that, because the description in the paper suggests that even though the judge tried to gracefully extricate himself from this inappropriate situation, the lady was angry, she was disgruntled, and he wasn't able to do it very as those of you familiar with our system are aware, one of the biggest weapons that judges have in avoiding problems of this kind is by reference to the rules of ethics, the rules of judicial conduct which govern their behavior. And I can only infer from the hypothetical discussed in Professor Moliterno's paper that system of regulation in Kosovo is not sufficiently well defined or well understood that the judge could say to Rita, Rita, I would love to be able to help you, but I'm precluded from talking with you about this because of rules governing my conduct that I could be sanctioned if I had this conversation. And so I'm sure you understand why I can't do it. I don't know whether, I know that judges use that sort of explanation all the time in a whole variety of situations to avoid getting involved in situations that would actually implicate the Code of Judicial Conduct. The second point I wanted to make that I derived from Jim Moliterno's paper related to his understandable reluctance to express an opinion as an expert about, I don't know what the word is, Kosovian ethics. But it seems to me that I can understand why he would be reluctant to be presumptuous enough to act like he understands culture, traditions, and rules of conduct governing judges there. But again, I would assume, Jim, that there was a way you could, without in any way denigrating their system, use our system by way of comparison. I'm not sure that I know enough about your system, Judge, so to give you an expert opinion that is consistent with your traditions, but in a comparable situation in the United States, here's how we would deal with the situation. And I am confident about that. I could go on, but I think it'd be better to open it up to questions.
Terrific. Thank you, Mark. I'm actually going to go back to Sarah first. I'll have her come up to the podium to respond to some of your comments, and then we'll open it to questions from the audience. I will, and indulge me, we've got a room full of people here, Mark, many of whom were nodding and smiling and agreeing with you at various points throughout, and I think we'll have a few questions for you. I'm going to have to repeat their questions in order that you're able to hear them. Okay?
I'll be super quick because I do hope there'll be some discussion. But there are two things I guess I would say. One is that there's something that I left out of the talk version just for purposes of time that I think is worth saying, just to respond to one thing that you said, Mark, and that has to do with the other end of the, not the conduct regulation end of the spectrum, but the appointments end. Because one thing that is, I think, significantly different, as I understand, both from reading about it and from anecdotal accounts, the confidence, whatever public confidence is, the confidence in the selection process in Canada and in England is way higher than it is in the US. And I think that makes a difference when it comes to sort of the reliability of the judicial conduct mechanisms. You can, I guess, forgive a little bit more at that end, perhaps, if you have that much confidence. I can't speak one way or the other to the confidence level in New Zealand and Australia. I sort of hear varying accounts. So that was one point. And the other point was to perhaps suggest at least a slight rehabilitation of the new federal code and procedures in the U.S. Just to say, one thing that I think is going right there is the new emphasis on publication, readily available on the circuit court websites, information about dispositions of any complaint that's filed. Now, often that that includes a retraction of the judge's name. But in terms of what actually happened and what the disposition was and why, that's actually, I think, one good thing that's involved in the new federal approach. But I will leave it at that so that we can have discussion.
Thanks, Sarah. So to you for some questions and comments, and actually I'll put a couple of people on the spot. First off to Merrill, actually, if I might. Good morning. With Mark's comments in particular on the merit selection process in Arizona and your discussion yesterday about some of these issues and the fact that you're I think you self-described as a convert to the process. I'm always interested in the commentary of those who have come around, if you will, to merit selection, and wanted to see what you might think about what Mark was saying about the way in which the Arizona process has unfolded. Mark, I'm speaking to Meryl Chertoff, who was presenting yesterday and is with us this morning.
Well, I think that Mark pointed out something that I had not discussed yesterday, which was the judicial review process and the evaluations. And I found that an interesting emphasis because that does increase the confidence in the judiciary. The point that he brought out that I think that I alluded to, and he made it even more clearly than I did, is that the transparency of the Arizona system is a key factor. The fact that there's a high degree of public access to the process ensures that there isn't this sense that things are going on, in the dark room that nobody comes out of, I think, as somebody said. So those are key factors. And of course, confidence breeds confidence. So over a period of time, there is both a public and a legal culture that has a high degree of confidence in the judiciary.
Okay, Mark, I don't know whether you were able to hear much of that. What Merrill was emphasizing was your emphasis on the judicial review and evaluations process, the emphasis on transparency, public access, and the notion that confidence breeds confidence. And let me actually go on that last part to make an observation from the Canadian system, where I'm chair this year of the Canadian Bar Association's National Ethics and Professional Issues Committee. There is a different committee that deals with judicial selection, and Sarah's quite right. They may not always agree on the candidates, and maybe Richard and I might differ, but I think there is, particularly with Supreme Court appointments, a tremendous confidence in the public. There has been some intersection and some efforts at different provincial levels to open up the process, but by and large it relies on an advisory set of committees. Now, there's been some controversy at the national level with the current incumbent government wanting to ensure that there's a representative from the police community, for example, on judicial appointment advisory committees, a specific representative from that committee. So there's been a bit of controversy. But by and large, other than that, there has been tremendous public confidence in the end result and in judges, tempered somewhat by a couple of these illustrations, and in particular the Cosgrove case, because he had been a liberal politician before his appointment to the federal court. So looking at judicial review, looking at merit selection and evaluations, I think what's interesting from my perspective, living in comparative land like Sarah does in a lot of the work that I do, is to see the ways in which culturally, even out of these common law traditions, you end up with similarly situated results at the end in terms of the expectations of the judges, but very different ways of getting there, and then problems that end up resulting. But we've got lots of expertise, both of judges and of others around the room, and I want to go to you. Sir.
Yes, I'm reminded of an elephant in the room. Roman Catholic Church, and there was a survey, an informal survey done by KCRA of Catholics in the city of Sacramento. What should the Pope do? 60% said he should step down. I'm also reminded of the idea of the fox in the chicken house. Police commissions to investigate abuses by police, which are made up of members of the public. I am concerned that judges are not subject to the same kind of scrutiny, and as far as Professor Harrison is concerned, I absolutely agree with him, and I think I'm a little bit familiar with the Arizona system, and I think that the reason that they are continuing to receive high marks is because of the involvement of the polity in this process. And getting to Professor Moliterno's, I'm reminded of the Indian Raj where they tried to impose English common law on the Hindu, Muslim, Buddhist, and other caste and tribal systems, wherein they had English judges who had before them lawyers from those various communities, and they didn't understand anything about the culture, and thus they had huge problems in terms of the empire. And we know what happened to them, don't we?
Two questions out of that, and actually let me break them apart. Mark, a vote of confidence in terms of the involvement of the polity and involvement of the public in the Arizona system. Let me come back to you for further comment on that, about how the public gets involved, how the members of the public are chosen or selected, and what your experience of their experience has been.
I think the gentleman who made the comment is absolutely correct about the effect of the involvement of the polity in the selection process, and it ties in directly with what Sarah said about why results in Canada are more acceptable in the comments you made. I have, coincidentally, my younger daughter, who is a lawyer, was appointed to the Arizona Appellate Nominating Commission 2 years ago. And she's now been, excuse me, through 3 cycles of judicial appointments in the appellate courts, one to the Supreme Court. And she has been absolutely blown away by the depth and breadth of the evaluation that goes on before that commission makes recommendations, number one. And number two, she said, Dad, there has not been, obviously the process has political overtones because the appointee is ultimately nominated by the incumbent governor. And almost invariably, with notable exceptions like Sandra Day O'Connor, the governor has appointed a nominee from his or her own party. But that said, the process itself, which does involve public members, a substantial number of public members, has not had any political any political pressure whatsoever. And I think that, as the gentleman said, as you pointed out, as Sarah pointed out, that has a great deal to do with whether the public ultimately has confidence in the appointees and in their decisions. One last point, there was a bill introduced in this legislature to emasculate merit selection, and I went to the hearing at the Senate, and the bill is sponsored by what I will politely call some right-wing Republicans who were talking very generally about accountability and I want everybody elected and so forth. And a Democrat on the committee said, let me see if I understand this. The legislature has a 15% approval rating for its work. The judiciary in Arizona has a 93% approval rating for its work. What am I missing here?
Thank you, Mark. Let me go to Jim actually for a response in terms of this whole question of the external imposition of a culture in the and we've had previous conversations about if for lack of a better word, the sort of the ugly American abroad telling people how they ought to think.
Right.
And that you've had some experience with that out of the ABA committees in which you served.
Yeah, there have been a couple of occasions that I was a little bit surprised to have people I worked with in Serbia and Thailand, in Czech Republic say to me, "You don't seem American to us." And I didn't know what to make of that at first. I thought I wasn't sure if I should be insulted or not. And they explained themselves, though, unfortunately. What they explained was that they expected that when the American got there, when I got to town and worked on this project, that I would just tell them what to do, that I wouldn't be interested in what they thought, I wouldn't pay any attention to them, and I would explain to them, right, that one of the great things about the U.S. is that nobody's like anybody else. You know, that was one of the wonderful things here, and that since they were experiencing somebody that wasn't doing that to them, they ought to maybe reform their picture of what Americans could be, you know. But in particular, you know, the gentleman mentioned the English experience in India, and Mark had mentioned that there ought to be some kind of gentle way that I could say, but this is how we do it in the U.S., and it is possible to do that. I have been exceptionally, I think, careful to try to diminish the impression of cultural imperialism that goes on in these projects. And so I do that in two ways. One is that instead of ever really just saying this is how we would do it in the US, I say this is how the European Union rules work on this. This is how the Japanese rules work on this. This is how the US rules work on this. here are some different choices. Here are different ways that this issue is handled. Sometimes they turn out to be the same way in all those places, but I never find myself just saying, this is how we do it in the US. People I work with on these projects hear that a lot. They hear, this is how we do it in the US, and very often there's sort of no other discussion to be had after that. This must be right because it's the way we do it in the US, and I think that's a mistake. The other thing I do is that I actually go ahead and role play the event myself as if I were a US judge doing it in the way I think we should do it, and that's a lot less imposing, right? So I'll replay this ex parte situation, and when the woman sits down and as soon as she starts talking about a case, I do what Mark suggested essentially, and I say, I'm very, very sorry, but there's certain things I can't do as a judge, and one of them is ever have a conversation outside my court about a case that's pending in my court. So I hope you enjoy the coffee. I hope you enjoy the lovely day, but I really have to excuse myself, and I get up and walk away. I did that once at one of the training sessions, and the judges cheered. I did it at another one of the training sessions, and they all raised their hands and they said, we can't do that. We would be rude. We would be regarded as being very rude in our communities if we did that. And then we would explore that. We would talk about what they meant by that and what the ramifications would be. So, thanks.
There's time for one comment, and Richard, you had your hand up.
Just pick up on Jim's point. I mean, I've been involved with quite a lot of judicial education around the world as well. One way we avoid sort of I'll call it the ugly North American, is we actually use what we call the Bangalore principles.
Yes,
right?
that's a great way to do it.
It's a set of principles that emerged from, quote unquote, the third world in a way itself. And I mean, on one level, they're pretty much the same general level principles, and they get deployed differently.
Right.
But it's one very effective mechanism of saying we can draw from your own communities, or parallel communities, and that works very effectively.
Mm-hmm. That's a great idea. Yeah.
With that, actually, I'm conscious of time for recaffeination. It's something that I believe in as well with Jim for any successful event. Mark, let me thank you for the special effort to be with us this morning and for your comments, and to the panel for terrific papers and a great way to start day number 2. Thank you very much.